This is a short video in preparation for the Arlington Chapter TFA meeting, September 10th, 2025. I wish I had good news to relate regarding the recent order of a three-judge panel in the Hughes v. Lee case, but I don't. After that landmark ruling, which resulted in a holding that said 3917-1307A, the intent to go armed statute, and 3917-1311A, the infringement on carrying a firearm in a park without a state-issued permit, unconstitutional, void, and without effect. The state has decided, at the insistence of Representative Chris Todd, to appeal and seek to stay the order which declared these two statutes unconstitutional. Of note, the first state legislator to openly call for the Attorney General to stand down on the appeal of that ruling was Senator Brent Taylor of Make Memphis Matter fame. The order was the culmination of 2 years of litigation which simply sought to remove these two unconstitutional statutes brought by Gun Owners of America, Gun Owners Foundation, Stephen Hughes, Elaine Kehel, and Duncan O'Mara. Defendants in the case were Governor Bill Lee and Attorney General Jonathan Skrmetti, Commissioner of the Department of Safety Jeff Long, David Salyers, Commissioner of the Tennessee Department of Environment and Conservation, Fredrick Agee, District Attorney for Crockett, Gibson, and Haywood counties, and Paul Thomas, Sheriff of Gibson County. Thomas singly stipulated that he agreed with the plaintiffs and was removed as a defendant because of that. Any of the others could have done the same, but chose not to. From the Attorney General's motion to stay, quote, the court's order appears to do away with any state law obstacle to a 10-year-old bringing a semi-automatic rifle to his rec league basketball game. The order similarly appears to erase any state prohibition against a shotgun-bearing drunk stumbling through a crowd on Broadway or across Market Square or through Shelby Farms. Prohibitions on such reckless conduct are plainly consistent with the Constitution as well as the preferences of the people of Tennessee. Preferences of the people? What if the people of Tennessee wanted all black citizens dead? Or all Jews? Does the Constitution's requirement from Article 11, Section 16 overshadow that ask? It says, the Declaration of Rights hereto prefixed is declared to be a part of the Constitution of this state and shall never be violated on any pretense whatever. And to guard against transgression of the high powers we have delegated, we declare that everything in the Bill of Rights contained is accepted out of the general powers of government and shall forever remain inviolate. The court's order does not set aside any statutes other than the intent to go armed in parks infringements. Other state and federal statutes, currently unchallenged, restricting access to firearms by certain individuals, prohibiting certain individuals from purchasing or possessing firearms, prohibiting certain individuals from carrying firearms, that prohibit reckless conduct or the possession of a handgun, or in some instances a firearm, while under the influence, that prohibit public intoxication. None of these are impacted by the court's ruling, but the Agee and the mainstream media spew the propaganda that it does. So now we will have to wait at least another year to know if the courts will do the right thing and recognize the pre-existing to the founding's right of the people to bear arms, without it being a crime, and have the state spend more of our tax dollars to try and keep that Jim Crow infringement on the books. Read the TFA emails, study the Constitution, follow my Substack atcricharchie.substack.com. I will leave you with my quote for the day. It is a settled and invariable principle that every right when withheld must have a remedy, and every injury its proper redress. Marbury versus Madison from 1803. Have a nice day.